Thank you so much, Tashante. Could you please indicate to me one more time, am I audible? Thank you so much. Good afternoon, everyone. Good afternoon, Dr. Visser. For those of you who don't know me, my name is Dialogue Jafta. I'm the Senior Mood Officer for Legal Behemoth. Yeah, so I am I am in charge of everything that has to do with senior moods. I'm sure you guys know that by now. So just not to waste more time, I just want to give you guys a brief background of what's going to happen. So Dr. Visser is going to be addressing us today. And then after Dr. Visser's presentation, we will give you guys an opportunity to ask questions. And then after that, I will just make two very important announcements. And then, yeah, that will be it. So let us enjoy the presentation. Dr. Visser, I am handing over to you.
Hi guys, it's very nice to see your names at least. Before I start, I just want to quickly check. You guys can hear me and can you see the slides? And you're welcome to type in the comment section because I can see there as well. So you don't have to mute yourself.
Dr. Visser, I can hear you and I can see the slides.
Okay, great stuff. And if it changes, you guys can see that?
Yes, Dr. Visser.
All right, cool. Right, guys, it's very nice to be here. It's very formal. I'm actually now grown a little bit nervous in the last 5 minutes since I've heard how formally you guys do things. But it's a pleasure to be here. And some of your names, I recognize you've been with me in the past. Some of you are with me now. It's very nice to see you always, even if it's just by name. Before I start, I just want to say 3 things. Number 1, if you suddenly lose me, my computer is a bit temperamental. It's a little bit like a teenage girl. So at times it automatically restarts. I have no idea why, and I have no way of predicting it. So if you lose me, please stay here. It takes me 2 minutes to come back. I will come back. Hopefully that won't happen. The second thing is, what on earth are you guys doing here on a Friday afternoon before your break starts? I'm very impressed with that you guys are actually here. That shows real dedication, because in my days as a student, I definitely wouldn't have wasted a Friday afternoon especially before a break. So thank you very much for being here. The third thing I want to say is I'm approaching this thing, you guys know me, I'm not a particularly formal lecturer. I don't approach things that way unless I walk into court, then things changes. But I try and do it informally. So please don't feel scared to ask questions. I really don't mind if you ask questions as I go through the slides, but the house rules are clear. So please write down questions. Don't forget it. Because I love questions, especially when you guys think it's stupid questions, because your questions are never stupid. And it's always just nice to hear what you guys are wondering about. So if I just get to the first slide, I want to explain to you how I prepared, or how I approached preparing this speech, because almost all of you, I suspect all of you, have had legal writing with me in the past, and I didn't want to repeat what I've said. I'm assuming that, some of it at least has entered your brain and stayed there for a little bit. So what I decided to do was talk to you as if you are no longer students. You are now going to practice, which some of you, of course, are. I also focused on what judges said, or what they say regularly about legal writing, specifically persuasive writing. When I designed the course, Legal Writing LPRC 2514, this was now very many years ago. When I started studying the literature, I realized that there's only one audience to speak to about this, and that's judges, presiding officers, magistrates, the people who are the end result of our writing. And as I go through it, I will tell you guys what they said. I didn't speak to every judge in South Africa, of course, but I spoke to many, and there's one theme that perpetuates or is pervasive through everything that all of them said, and that's something important to remember. And it's so simple, it's hard not to imagine that it's logical. But as you will see from stats that I'll show you, it's really not logical. I also focused a lot on research about judges in America and elsewhere, and what judges said, what they've published on legal writing. So a lot of stuff that I'm about to say, you guys have heard before. I've said this in legal writing. I'm not going to leave out something that's really super important, but I've tried to make it more real and to give you guys a real glimpse of what it is in practice. I'm very sorry that when I practiced law, I didn't have legal writing before. Legal writing only came in when I became a lecturer. And that for me is a shame, because now I realize that some of the techniques I used in practice really wasn't me being brilliant. It was what I picked up that is commonly used by good legal practitioners. So I learned from good people, but I wished I had known more. Now I feel like if I walked into a courtroom, I'd do much better, win every case, if I had just known what I know now. So I hope that what I present to you today helps you in the future. Please understand that it comes with a very sincere heart and a very sincere attempt to make you better lawyers, not to impress you from an academic standpoint. Right, so that is the angle with which I'm presenting this lecture, is from the perspective that you guys are all legal practitioners. And since you guys are moot court arguers, that makes you legal practitioners. So I sent this to a master's class that I taught recently at the University of Northwest, where a lot of magistrates and prosecutors also attended. And they had interesting answers. I said to them, if law is freely available to everyone, and I mean, we know that legislation is freely available to every citizen in this country, case law is now freely available on the internet, and the vast majority of academic texts, these accredited articles, are now what they call open access. So it's free for everybody to get. So if your high school sister or niece or nephew or brother, or, that really annoying aunt or uncle that always seems to know better than everybody else, if they can get the law with complete ease, why do we bother paying all that money for LLB degrees? Why do we put ourselves through 4, 5, 6, 7 years of absolute suffering? Why bother studying law if what you need to practice law is freely available? Have you guys ever thought about that? Well, I have, especially when in my final year of LLB, I thought about that a lot. So we study law to learn how to use the law. And I hate to break it to you, but applying law to facts is but a very small aspect of practicing the law and knowing how to apply that law, doing with it things that nobody else can do in order for you to win your cases. We study law to get a very thorough, more thorough than I think you guys have now. But we study law to get a thorough understanding of law, and we learn how to argue, especially you guys who take part in moot court competitions. And we do this because we want to win. Let's get real. Let's leave the nonsense for another day. We study law because we want to win cases. That means different things for different people. For me, it means I wanted to make the streets of our country safer. For someone else, it means they want to make particularly women safer. For other people, it means that when it comes to real big companies and taking over companies, saving companies, or destroying companies is a win. For other people, it simply means that they will spend their entire lives studying what the law says and how it really what it should say. So winning means different things for different people. But at the end of the day, what we want in law is to win. If this had not been the case, we would never have worked in an adversarial system of procedure. So that is the ultimate goal, is to win. To win, you have to do those wonderful things with the law that hopefully you will be able to do when you get to practice. And to do that, we need two things predominantly. And this is what research tells us, including research done by the Legal Practice Council. We need to be able to argue, and we need to be able to transport those arguments into the written and spoken word. So the spoken word is up to you guys. Take part in moot courts, speak in classes. It's something that you can learn. It's not something you have to be born with. But writing is by far the more important skill, because our oral presentations, our oral arguments in court comes from good writing. If you cannot found your arguments in good writing, then you'll stand in a courtroom with a mouthful of teeth and have nothing to say. You will see when you get to practice. The writing in practice is really bad. And that is true for several reasons. One is ignorance. People just don't know how important legal writing is or how important writing is to a legal practitioner. There's also very few legal practitioners who bother getting literature, handbooks, articles. And I'm telling you guys, there is a sea of literature on good legal writing, persuasive legal writing, anything you need to know about legal writing. Very few people bother with that. Very few universities present legal writing as a core module. We are one of very few, us, UCT, Stellenbosch, and I think Wits, I don't know about the other universities, but we were very quick on the pickup. We knew that this was becoming more important worldwide, and we presented this. So ignorance is a big problem. Now, you guys going into legal practice will hopefully have learned about legal writing, but you are a very small fraction of the legal fraternity out there. The older legal practitioners who, like me, never had legal writing simply don't understand what they are doing, and they don't understand how improving what they are doing can improve their businesses and the practice of the law. Secondly, mentorship. I'm sure that you guys have experienced this before. I told you in legal writing in your second year, this is how you write in law. I'm almost 100% sure that as you proceeded throughout your years at university, other lecturers told you different things. I'm sure that at some point you came to a lecturer or a legal practitioner who told you to formalize your writing, to sound more lawyerly, to include words like henceforth and herewith. I know that because my old students tell me, and I know what I was told when I went into practice. The third reason why writing is bad, and really bad, is because of misdirected intent. Now, we all want to make the legal profession proud. I want to be part of a profession with decorum and pride, and that in the way that we conduct our business, we show people that we are the strong ones. We are the ones who stand up for those who cannot stand up for themselves. And we would like to do that in a manner that is admirable. But that does not mean that the way that we write and the way that we argue should be beyond understanding. So when I mark student assignments, I oftentimes need to tell a student, don't try and sound like something. I want to hear your voice. Speak to me directly. The misdirected intent is because we want to sound formal. We want to sound impressive. And sometimes we think that the more impressive we sound, the more persuasive we'll be. And in fact, the opposite is true. Another thing, and especially with students, and I was definitely one of those, with students who love reading and who really enjoy writing. Students who engage in debates, who did debating at school and who did so at university, they tend to enhance the writing with really good sounding formal words. And that can be devastating to a case. We must remind ourselves that we are lawyers. How you write when you are sitting in your sitting room in front of your computer, drafting your first novel or your poetry compilation, that's 100% your business. But how we write when we practice law is a very technical, very unpretty, very uninteresting to laypersons type of writing. So we need to remind ourselves what we are doing. We want to win cases. We don't want to impress people. We will impress people by the amount of cases we win. To win cases, we need to let go of that idea of how we should sound to the world out there. We also need to remind ourselves, and this is a very important point, who our audience is. At varsity, your audience will be lecturers, and different lecturers want different things. Very many of my colleagues don't put as high a price on legal writing as I do. So, some of the reasons are that they have other very important things that they deal with. Some of them were never in practice and don't realize how important it is. Some just think it's unfair to burden students with the expectation of good writing as well, which it isn't, because that expectation lives in practice very fiercely. If you look at the screen, your audience one day will not be lecturers. It will not be people who are paid to train you. It will be people who are trained to make sure that this country, that justice triumphs in this country. These are photographs of 4 judges, but it could very well have been principals in a law firm, CEOs of a company, commissioners at the CCMA, magistrates in the regionals or district courts. Your audience will be very busy people who have very high expectations and must decide points of law. They have no interest in being impressed. They have no interest in being entertained. They want to get the job done. In that sense, we all have to also ask ourselves, what is the objective of why I'm writing? If you are writing assignments at varsity, it's easy because you've done the subjects, you know what the lecturer wants, you put it down on a paper, you do it as well as you can, and you move on with your life. Each and every case that you will be dealing with is different. Each and every case will have a different theme and will have different reasons why it should succeed. You have to ask yourself, what am I doing? We persuade judges. That is how we win cases. And we do that by structuring our writing in a way that persuades the presiding officer that your case should win above your opponents. So this is a really interesting research that I found that was done in 2008. The entire judiciary in the United States of America was subjected to this research. So what this person did is that she sent surveys to all the judges in the United States of America to glean their idea of how good or how bad legal writing is in the United States of America. Now, just as a side note, the plain language movement that I told you guys about in legal writing has been ongoing in the United States for the last about 30 years. In most of the law faculties, they have departments of legal writing, and they present legal writing in all 3 years of legal studies. That's how important it is there. So keep that in mind. So considering how well they train their lawyers in legal writing, this researcher set out to investigate from a judge's point of view, what are their opinions about how the lawyers write in the United States of America. Fascinating articles. I can send it to you guys, those of you who are interested. So the first finding that the researcher discovered was that the vast majority of judges in the United States feel that lawyers have an inability to use relevant and binding authority to the advantage of their specific case. So the judges, they found that, the lawyers there can find sources very well. They can cite the sources perfectly, but they don't know how to properly use that case analysis. Now, when I read this, I was like, but this is my students, because you guys have almost perfected the art of analyzing a case by itself. This is what happened in this case. This was the legal issue, and these were the reasons for the finding. But that's about a third of what you need to do with law. And these judges found that, as true as it is for law students, that really doesn't develop when lawyers become legal practitioners. The judges found that there was a lack of rigorous analysis. Let me just see if I'm in the right place. Yes, I am. A lack of proper, rigorous analysis. In other words, you take 1 or 2 or 3 cases, or how many cases are applicable to a particular matter, and you pull it apart and you argue on it in one side and in the other. The researcher also found that judges complain a lot about the poorly structured writing of lawyers. They've complained that there's no ordering. The lawyers, present their arguments in random order, instead of starting with the really strongest arguments and working their way down to the weaker ones. They also don't provide road mapping. Now, I hope you guys don't make yourself guilty of this sin, because I teach you very categorically in legal writing, always include an introduction. And the American judges' complaints were that American lawyers don't do this properly. Also, a huge complaint from the judges was the presentation and language that they saw in lawyers' writing. They complained about grammar, punctuation, spelling, lack of proper editing of the work, and they complained of tone, which is interesting thing I'll get to later. They also said, and this is the thing that I found with South African judges, the one thing that they continuously said to me, Jomi, tell your students to write clearly. Tell them to cut what's not necessary. The one said to me, it's fine, I take a red pen and I drag it through everything until I get to something that's actually applicable to the case. Judges complain that lawyers' writing is simply not clear enough and it's not concise enough. Now, if you don't recognize these two words, you know, my job in life has failed and I should leave the varsity, because the two things that I hammered on in legal writing was that clarity and conciseness are two of the most important characteristics of really good legal writing. So what? The researcher delved even further into these issues, and she asked the judges to recommend. If they are unhappy with one thing, what do they want? And the judges said, you know what, identify your legal issues pretty good. I mean, that goes without saying, because we don't have cases without good legal issues. They also said, find binding and persuasive authority. If you have a case like, you know, your client is being threatened with, you know, death by hanging, death penalty, that is such an easy case to argue, and that's the first thing that just came to my mind. But there are other issues on which we have binding authority in this country. In those cases, you know, that's an hour prep before we go into court, because there's binding authority that is from the Constitutional Court that gives nobody options in terms of what the final decision will be. Easy. But the vast majority of cases that you guys will handle in your career will be cases on which there aren't any binding authority, that you actually have to argue. And these judges were saying, you know, get your binding authority, of course, and goes without saying, but don't stop there. Find persuasive authority too. Dare to make those arguments. The judges also said, make strong arguments. Those of you who have taken part in moot court for a really long time understand the art of arguing perhaps better than those of us who never did that. Proper argumentation means that you not only understand the material really well, but you can manipulate it into two directions, for your client or against your client. The really good litigator understands that he must be able to argue against his own case almost as good as he can argue for his case. Why is this important? Because good legal practitioners anticipate moves. You are a litigator if you know what's coming. You are a litigator. You know that thing that you hear in movies, don't ask a question if you don't know the answer? It's sort of true in the sense that a good litigator will anticipate answers, anticipate what the prosecutor will do here, anticipate what defense counsel will do. And you can only do that if you know what material is available on your case. If you don't know the case is against your case, you're going to lose. I don't care how strong you think your arguments are. I don't care how strong you think the persuasive authority is that you got. You're going to lose your case because you are unprepared. So make strong arguments for and against your case. Attack your opponent's arguments. Don't spend the entire case doing that, of course, but you have to. I mean, this is why I said for the assignments, make arguments against your own case as well. Anticipate what your opposition will do, because they will do it. Now, if you know what they're going to do, you can prepare an offense. You can win your case. If you don't anticipate your opponent's moves, you can't attack it. Going into litigation, you guys are going to be inexperienced when you go into your cases. Your opposition will expect you not to attack them because they will expect you to just try and survive the case. Don't fall for that. Anticipate what your opposition will do and be ready to attack that, either with authority or with arguments or any other strategy. Find policy reasons why you should win. If the law is against your case, find policy reasons why you should win. The advocates who argued that the death penalty is unconstitutional, now in retrospect, we think, you know what, heroes. These are people who advance the spirit of the Constitution. You know, hey, well done. But you must remember back then, there was, and I mean, to a large extent, there still is, a large population of our country who believes we should bring it back. It was not a popular argument to make. It's still not a popular argument to make. But they argued on policy reasons that then translated into constitutional reasons, that should not happen. Find policy reasons why you should win. If the law is against you, should the law change? Don't stare yourself blind against the existing law. If the law must change, then you argue the law must change. And then in 20 years from now, I will tell my students that that person who fought for that law to change was my student, and I will take all the credit for it. So the one judge wrote to because the researcher in this research project invited the judges to write in hand notes to her in support of what they said in the surveys and in order for her to understand the issue better. And one judge wrote, "Judges too want to know what to make of the applicable law, and lawyers are missing a great opportunity to influence their thinking. Only 23% of the judges rated the quality of legal analysis in briefs excellent or very good. So that means 67% of judges in the United States feel that legal analysis in America is done on an average to poor basis. And that is really not good news for the legal system in America. And let's not pretend that it's going to be any better in this country. So I think that's very important. Some of the judges' comments that she received, one judge said, frequently analysis is superficial, relying on the case or cases that the writer subjectively thinks are helpful without sufficiently recognizing and rebutting contrary readings and without explaining how the law has developed. Here's the thing. If you are looking for really good lawyers, go to judges and ask them, whose heads of argument have you stolen? Let me explain that. You guys know by now that when you do litigation, especially in the High Court, you offer the court your heads of argument. In other words, your arguments on paper. Now, very many judges, when they read these heads of argument, are persuaded one way or the other by these really good heads of argument. Then they take that heads of argument and they adapt it slightly, and that then becomes the case that you guys read. That happens when the heads of argument does a very good job of legal analysis, in other words, setting out the law and explaining how it applies, and does a very good job of making arguments so strong that just by reading that, you can absolutely find in favor of the counsel that wrote that heads of argument. The judge then takes that heads of argument, tweaks it a little bit, and then that becomes the judgment. Judges do that often. They don't go around telling everybody that, but they do that often. But they do that when the heads of arguments are strong enough for that to be done. You guys need to draft heads of argument that are so strong that judges steal it. That should be your objective. The average heads of argument that lawyers submit consist of the facts, then an explanation of what law applies, and then the superficial application of the law to the facts. In other words, Section 1A of the Law of Evidence Amendment Act 45 of 1988 says this about hearsay evidence. This person was not present. He was deceased. Only his statement was submitted. Therefore, it is hearsay evidence and should not be admitted. Next argument. They leave it there. That's what the legislation says. Let's move on. In the meantime, there are about 12 cases that talk about the exceptional circumstances in which that hearsay can be admissible. So you have to really know the law. So your career is going to be reading, my friends. I hope you know that. And you have to be brave enough to make arguments. You guys know how to support arguments. Trust me, I've seen you get really good sources, and I've seen you be at the brink of creating those strong arguments. But then you stop at, this is what the law says, this is the facts, therefore. And this is what this judge essentially said. So the next judge said, too much of the brief is devoted, by the way, a brief in America is heads of argument. Too much of the brief is devoted to issues that are not in substantial dispute, or there's too much emphasis on a point where the court's unlikely to base its decision. That happens, we see that with student work when a student sort of glances over the real issue because it's difficult, or present all the facts in a case and none of the ratio, and then they just sort of glance over the really important stuff. And that happens in practice too. So another judge said, counsel often waste words on trivial issues and neglect to focus more on the application of controlling case law to the particular facts of a case. Too often, all lawyers do is cite cases. Rarely do they do a good job of analysis. You can tell that this judge has had enough. Another judge said most of the briefs lack proper analysis of legal and factual issues. They ignore or gloss over obvious weaknesses in their argument and fail to address the compelling counterpoints of the other side. Another judge said, we often get the feeling, law clerks and me, that the parties are satisfied simply to identify the issues and leave the rigorous research and analysis to the courts. When lawyers do apply the controlling or binding law to the facts, they are only moderately successful. Only 19% of judges consider advocates' use of precedents in analogizing or distinguishing cases to be excellent or very good. And this is the really shocking part. No judges rated advocates' use of precedent as excellent. American judges talking about American lawyers. So let's talk about the whole idea about structuring arguments. You want to really think about how you present your case. And this is incredibly important in persuasive writing because, guys, the truth is, and listen, ask any lecturer about this, I can tell you it's true. You can lose an audience like that. And remember that your presiding officers are just human beings. They are incredibly well trained, and I still believe that South Africa's bench is one of the best in the world. But you are going to lose your audience if you don't spend time looking at how you're going to tell your story. Because at the end of the day, everything is a narrative. It's a good idea to start with your strong arguments so that you don't lose your audience. Make sure that you have a short, very clear introduction in which you say, this is what I'm going to do, and this is where I'm going to do it. So I'm working on an article now, and I think this time I did a good job of the introduction, because I said at the end of the introduction, I offer this article in 3 parts. Part 1, I'm going to do this. Part 2, I'm going to do this. And in part 3, I'm going to do this. My really strong mini thesis students, they do exactly the same thing. At the beginning of each chapter, they tell me, this is what's going to happen in this chapter. At the end of that chapter, they tell me, this is what happened in this chapter. That's structuring. That is guiding. Writers like Stephen King and J.K. Rowling, they allow their reader to enjoy the story. You can't do that. You need to take your reader by the hand and take him or her where you want him or her to go. They don't have a choice. They shouldn't have a choice. Emphasize what is strong and hide what is weak. So let's talk about language. Now, in this research, what I found very interesting was that judges in the survey didn't seem to mind legalese. Now, I was honest with you guys when I taught you legal writing that you don't use legalese when you write to clients. That's a big no-no. But you can and you should use legalese if it's appropriate when you draft your heads of argument, when you write for judges. Because obviously, if someone is going to understand what prima facie means, it's going to be a judge. And we shouldn't annoy a judge by trying to replace prima facie with some English words because it just doesn't fit. So judges really don't seem to mind legalese. It shouldn't be bad. It shouldn't be, grandiose and cumbersome. But the legalese that exists, or the legal jargon, I think, is a better reference to the concept. They really don't mind that. Judges do mind. And I spoke to a judge last week on an issue that's very sensitive to me. And I can confirm that South African judges feel the same way. Judges do not like attitude in courtrooms. Judges take their job by far very serious, and they don't appreciate, and of course I'm generalizing now, but it should be true for everybody. Judges want to decide matters on the law. They will always try and keep all external influences out of their decisions. Judges are aware of bias and what bias can do, so they always try and also account for that. The judges that I know well are all people who work very hard to maintain a sense of impartiality. So they don't like when 2 parties stand in court and start taking on one another on a personal level. They love it when two great minds start arguing about issues. In fact, I'm getting goosebumps just thinking about it. Judges love that. The judge that I spoke to last week told me about this really fascinating medical law case in which two of Bloemfontein's most experienced advocates both had extremely good authority and extremely good arguments. And this judge was getting so excited, telling me, you know, it was so exciting looking at these two lawyers and seeing how they absolutely gun for each other in terms of argument. You listen to the one and you think, this I'm going to find in favor of this argument, and then you listen to the other party and suddenly you feel like you've got to find here. That is the kind of competition battle, accusatorial battle that judges are looking for. And in United States, judges feel that that exists in America. I'm concerned for South Africa about this, because what I've been reading recently in newspaper reports, and maybe you guys have picked up on this as well, that there's a sense of losing that decorum in our courtrooms because some legal practitioners are speaking to the bench in a manner that is incredibly disrespectful. Now, listen, I don't bow to people because, first of all, I wasn't raised that way. Second of all, I wasn't raised in a monarchy, so I've never bowed to a princess or a prince or whatever. So when I had to walk into the courtroom for the first time and bow, it felt a little bit, in Afrikaans there's this really nice word, volksvreemd. It felt very strange to me. But when you realize that the person sitting there is not a person, it's the court, it feels much different. Then the bowing started feeling to me like this is me being part of something that's bigger than me. Those people sitting on that bench are people when they walk out of that courtroom. Then they can sort of kick the dog and, be normal humans. But when they're sitting on that bench, I don't see the human. I see the court that I serve. So we should fight and we should stand up when unfair decisions are made. And we should stand up where recusal is necessary. But the manner in which we do it says a lot more about us than it says about the court. That exists on a plane higher than us. So my personal feeling, and this really is just a personal feeling, is that we should always maintain that decorum. American judges are completely satisfied with how it's going there. I hope our judges are as well, but one must always sort of check yourself. Judges want good grammar in spelling and editing. For them, perfect referencing is important, but it's less important than good spelling, good grammar, good paragraphing, good strong sentences. And the reason why they need this is because these are the tools that form your argument. If it's unclear, they're not going to read your sentence for a second time. You had one opportunity to persuade that judge and you failed. So incredibly important. And, this is the thing that I think is a shame, that when we grow up, that, if you talk a lot or if you are very assertive and you've got a very good voice, as some of my students have, then people tend to say, oh, you should be a lawyer. But if you are a really good writer, if you can move people to tears or you can make people angry or you can really change the way that someone thinks about something, nobody's going to tell you to be a writer, and that is really how it's supposed to be. And this is what one judge said, and I thought, this could have been said by one of the judges that I spoke to. I've heard this so often. Whether we mean to or not, we judges tend to become suspects of any argument advanced by an advocate who produces shoddy work. I have little trust in an advocate who files a document that contains misspellings, poor grammar, or citation to bad law. Bad law meaning law that's been, repealed, cases that are really old and it's been replaced by more recent and more persuasive ones. This is what this judge means. And this happens all the time, guys. So the complaint about not submitting work that's not clear and concise enough, when asked this is what the researcher says, when asked how important conciseness, and conciseness really is just a fancy word for briefness, how important conciseness is to legal writing's persuasiveness, 90% of judges said that conciseness is essential or very important. However, none of the judges said that advocates are always concise and only 19% said that advocates are usually concise. In fact, 75% of the judges said that advocates are only sometimes concise. Conciseness is very difficult because people think the more words you take to say something, the better you are. I mean, look at Anna Karenina. That book, is considered to be this brilliant book, really, really thick book. That's not how we write. The more you can cut, the better your writing will become. So these are some of the comments that the judges made to the researcher. The one judge just rambled on. Lawyers just ramble on. And you know what? When I was practicing law, there was this particular one day that I was practicing against a Bloemfontein attorney. I think he did a good job of trying to defend the accused. But in the final address at the end of the trial, I was very brief in what I said. And he stood up and he went on and on and on. It took almost an hour to speak on a case that took a day to hear all the evidence on. And at one point I was looking at him, and this was a point where I started daydreaming about 17 minutes into his speech. And then at the end I thought to myself, I am 100% convinced that everything that he had said between me when I started daydreaming and then when I started listening again was completely useless in any case. And of course, he lost the case. And I thought to myself, that entire hour, that attempt at persuading the court is so well meant. The intention is so good. But if you understand presiding officers, you know that it's better to come to a knife fight with a gun than it is to try and persuade the judge that a dead horse really is alive. And that expression I heard almost every day practicing, because magistrates love that expression. Are you going to continue hitting this dead horse? That just means that the case is going absolutely nowhere. So judges are not fond of the rambling on. So if you find yourself rambling on, you need to ask yourself, have you lost the point? Because you need to get back to it, and you need to get back to it really quickly. One judge said their briefs are almost invariably too long and frequently repetitious. Verbosity and overcitation. Often important and concise points are lost in a sea of irrelevant points. So when I designed the course, I asked judges, okay, what do you want me to say? Here I am. What do you want me to say to students? And the one thing that reverberated through all of their advice was tell them to keep it concise. Cut out what is not necessary. And these are the comments by the American judges. You need to stress the need to write clearly and concisely. We are drowning in 50-page briefs that are poorly written when the case should have been 20 pages long. A brief can be brief. Heads of argument should be brief. Please tell your students that I have a lot to do and little time to do it. Write a brief that I can adopt as my own with a straight face, and you will please me. And this, I had to smile when I read this, because this is that thing when judges steal heads of argument. When your heads of argument is so good that the judge must steal it. How to say something concisely and once. That's what we should teach our students. We read about 1,000 pages a day and don't have time for rambling briefs that are poorly organized. Excessive length may hurt your case. Students should be made to understand that in today's world of crowded dockets, a judge has only a limited amount of time to devote to each case, and that the good advocate must be sure that none of that time is wasted. If briefs are too long, the judge's attention will often stray, and good arguments will be lost in the sea of irrelevance. Guys, whatever you write, whenever you write it, keep it clear. If you find it difficult to be clear, 9.9% of the time, or 99.9% of the time, it's because you don't thoroughly understand it. And that's true for all of us. I'm currently working on an article that I'm really, really struggling with. And the point that I'm struggling with now is because I don't understand how two judges think. And I need to get the two together, and I don't know how they argued on a specific point. Then you keep reading. You keep studying. You know those movies where a detective is going over the cases of the crime scene over and over, and you have to wonder, but this guy has looked at the crime scene photos now 6.7 million times. What is he looking at it for? They are rereading the witness statement 73,000 times. Why are they still reading it? They are reading it and they are looking at it because they don't yet properly understand. You keep reading and you keep looking until you understand, and then your thoughts become clear. And the moment your thoughts become clear, your writing is going to clear up like that. Say what you mean to say. You know, at varsity, I hear a lot of students say, yeah, but I meant to say that. You should give me the marks, you know, about what I meant to say. In law practice, you have one shot. So say what you mean to say. Find a way to express that. You should write in a manner that makes only one interpretation possible. And again, clarity is that way. Don't tell me that a feline, the color of darkest nights, is perched on his hindquarters on a mat of equal darkness. Tell me that a black cat is sitting on a black mat. So find the shortest, simplest way of saying a thing. There is where the power lies. The power is not in fancy words. And stick to your voice. And now we get to something that's very close to my heart. So when I went for my interview as a prosecutor, I was sitting in this really small, very clinical, very, very sort of intimidating little room with other people who had been invited to the interview. And this girl, who I later knew as Yvonne, sat next to me. And she was a mess of nerves. And all she said to me, of course, I was also nervous, but the whole time she said to me, I'm so scared I'm going to make a mistake in English. And for me, I thought to myself, I'm just scared I'm going to walk in there, fall on my face and not say a single thing correctly. I was worrying about law and me not knowing anything about the law and sounding like a schmuck and not getting my dream job. She was worried about making a mistake in English. Now, for some reason, Yvonne became a friend later. We both got the job. It was brilliant. But over the years of being a prosecutor and then the years of being a lecturer and then studying African languages, because this year I had the privilege of studying African languages through UNISA, I can tell you guys this with a lot of confidence. All of us, every single human being in this country, without exception, speaks English with an accent. Some accents are heavy and make the understanding of it a little bit more difficult. Some accents sounds like it belongs maybe in a palace somewhere, but we all speak with an accent. All of us, every single one of us. You should never let that stop you from speaking. That is a devastating mistake to make. Be proud of your accent. I've got a horrible one. I'm not particularly proud of it, but I'm not going to let it stand in my way. You should never let it stand in your way. Very few people in this country write English in a first and in mother tongue. Most of us, the vast majority of us, write English as a second, third, or even fourth language. And I want to tell you today, from my experience, that should not hinder your persuasiveness. Because true persuasiveness lies in simplicity. In my time studying this year, I discovered how the Khoisan tribe, for example, told their kids stories using animals in the time of deep segregation and how beautiful those stories was and what those stories meant. That is persuasive legal writing. Being able to simply tell a story that moves does not require the thesaurus. It does not require fancy words. It does not require sentence after sentence after sentence. It requires simplicity. And that is how we persuade. And you should never let who you are or how you speak or how you sound stand in the way of that. No reason for that to happen. Use the shortest possible words. And sometimes the shortest meaningful word, the best possible word for a context, is maybe a longer word. But you should never, ever use thesaurus to replace a good word with what you think is a better one because it sounds so lovely. Don't ever do that. When I just started as a lecturer at the varsity, I had this disease. When I was writing articles, I had to make it sound posh, you know? So I would write and I would sort of replace simple, straightforward words with really posh ones from the thesaurus because I told myself I know how to use the thesaurus. And when I read those articles now, I really cringe because I think to myself, I was so bad at this because you can absolutely, the pomp and the arrogance of it sort of just jumps out at you. I annoy myself in those articles. So that's how I've learned. I've noted my own bad writing. Hopefully I'm improving. Hopefully I'll improve 20 years from now. But don't use a thesaurus. Even Stephen King, who is arguably one of the world's greatest writers, hates the thesaurus. He thinks we should just set it on fire and get done with it. If you absolutely have to find a word, of course, then you go for the dictionaries and the thesaurus and the, Cambridge dictionary. But if you have a word in your mind that suits the context, you go right ahead and you use that word. Ensure proper grammar and punctuation. This is sometimes difficult for someone who's not comfortable with English, who maybe didn't read a lot of English growing up, who maybe was in a school where English wasn't presented. That's fine. You should still not let that stand in your way. Readers, my advice always to young lawyers is, it's good to read cases, but sometimes cases can be a little, bad writing, because judges also tend to write in a higher register, which is not great. Sometimes judges also don't express themselves beautifully. The best thing you can do for your writing is to read as many newspapers as you can. And I don't talk about The Sun. I'm talking about really reputable, credible newspapers. Because journalists have perfected or are at least very good at the art of writing persuasively and manipulating the reader's attention to a specific spot, highlighting what is important, and, good spelling, good grammar, that sort of thing. So the best thing that you can do for your legal writing is to read as many good newspapers as you can. And remember punctuation. Afrikaans students have a real struggle with using a comma. I don't know what they were teaching in schools these days, but when we still taught Afrikaans double medium, the Afrikaans students' ability when it comes to punctuation was much worse than the English students. And keep in mind that the Afrikaans students were educated in their mother tongue, which I always found a very interesting finding. I wish someone would do research on that. I think the thing is, if you grow up with bad habits, it's quite difficult to unlearn. But brings me back to my point, punctuation really is important. Don't overuse those commas. They are only there to create a breath. Know when to put apostrophes. Goodness, apostrophes are always an issue. Note where apostrophes come. Is it there, or there? So make sure these things, and look, this is something that I learn every single day. We as legal practitioners will develop these skills until we retire one day or die one day. This is something we will continue to learn, and we should. Some other points or hints. When you choose words to describe something, make sure that you use concrete words unless you are trying to hide something. The other day, I was teaching my law of evidence students about cross-examination. And those of you who've been with me for law of evidence would know that I use the Oscar Pistorius trial for the cross-examination that was done there. And I was sort of editing the one video where the prosecutor was posing leading questions to the accused. And he said, were you aiming the gun or were you pointing the gun? And, my friends who are not lawyers would also say, but what the hell is the difference? It's exactly the same damn thing. And I was like, no, it's not the same thing. The accused defense was that he fought for his own life. Private defense, putative private defense, but private defense nonetheless. The prosecutor was trying to say that this guy did this with intent to kill that particular person. So aiming, and were you aiming the gun or were you pointing the gun? I can't remember what words he used exactly. But you could argue that that question was not posed in a vacuum, because if he chose one word, the next question would have been, okay, but you just said that you aimed the gun, so you wanted to shoot that person. So that's what good preparation does. It allows you to use certain words to manipulate the person to answer in a certain way so that you can use that answer in the next question. So your word choice is insanely important. If you want to really describe a scene very well, you're not going to say that you got into the vehicle and they sped away. Was it a bakkie? Was it a school bus? Was it a motorcycle? Was it a skateboard? You have to be concrete in your word choices, unless you are trying to hide something, unless you want to soften stuff that's really bad for your case. Then you can go all vehicle. He didn't beat the person with a bat. He was assaulted. So your word choice is insanely important. Then avoid tautology. Don't say the same thing twice. Dead corpse, round circle, that sort of thing. Use gender neutral language. Now, I've said to you guys quite a few times, and I still see it everywhere. This thing where you write he or she is driving me nuts. Or he/she is even worse. These judges, as you just saw, they read thousands upon thousands of pages per day. So when you write he or she would go there so that he or she can get a job, so that he or she can feed children. That is incredibly interruptive to smooth reading. Choose a gender and stick with it. Well, you have three options. Number one, you can choose a gender and just stick with it. That's what I do. If you really want to, you can include in a footnote, all references to he should be seen as she. You could, in one paragraph, refer to he and the second one refer to she. I think that can be confusing, so I don't love that. Or you can just use gender neutral language. Instead of saying he should work so that he can feed his children, they should work so that they can feed their children. You have options, but please do not use he/she. That is an incredibly bad use of words. Also, don't overemphasize things. If someone is very, if someone is running very quickly, they're sprinting. So qualifiers, these sorts of things aren't ideal. We've got a hand up.
Thank you so much. I want you to ask us in the context of gender pronouns and progress that there. Do you intend to rather make reference to they and to he or she be more inclusive?
Sorry, you broke up quite badly. I will answer what I heard, and then please you could just repeat your question if I didn't answer your question correctly. Look, remember, we are not. When I, as lecturer, draft documents for students, I want to be the kind of person who is sensitive to people's ideas about themselves. So, of course, when I say hi guys, I never ever mean to suggest that everybody in the audience are men. When I say guys and girls, I never mean to suggest that anybody is immature or children. When we draft heads of argument, you are talking about specific people. So when you are talking about him having to get a job to feed his kids, if your client is a male, that makes it easy. If your client is a male who prefers to be recognized as a female, then you can write she. And if anybody asks you a question, if anybody is wondering about it, they can ask you. When you talk about they, obviously it should be in a context where you are not speaking about someone specific. So then, for example, if you say in a heads of argument that when a man beats a woman regularly, his wife in a regular, continuous fashion, and it becomes progressively more serious, that man should, or that woman should report the incidences to the police. That woman should go to the doctor. Then again, you've got gender-specific roles. If you are talking about a context in a heads of argument in which gender roles are not identified, you can just pick a gender because it's about the arguments. It's not about the gender roles. Tochanta, I hope I answered your question.
Yes, thank you so much.
Okay, I'm glad. So you also want to avoid negative structures, and on the slide here are some examples. It's not on, we see these things regularly in your writing. It's not uncommon for us to see these things in your writing. Failed to show inability. Goodness, that's not a double negative, that's like a triple negative. Not insignificant. It's significant. If it's not insignificant, it's significant. So cut this sort of stuff out because it annoys judges. Let's move on. Conciseness, very important. And I always remind writers that conciseness does not mean that you get to the point as quickly as possible. What's the sprinter's name? Why am I'm blank now? What is the sprinter's name, guys, from Jamaica? Anyway, when he sprints.
Is it not Usain Bolt.
Yeah, Usain Bolt. When he sprints, he doesn't sort of, when the gun goes off, he gets on a motorcycle and he speeds past everybody to the winning line. He runs exactly the same length or distance as everybody else, but he does so bloody quickly. And exactly the same spirit. You must get to the point as quickly as possible without breaking the rules of grammar. It does not mean that we write in telegram style. It just means we leave out what is not important. So some nominalizations, this is stuff we see in student writing regularly, and I see in emails very regularly. So a bad legal writer turns verbs into nouns and then adds another verb to take the place of the original verb. Like, we have reached a conclusion. Why not just we've concluded? I will grant a continuance. We'll continue. He was involved in a collision. Then he collided. We will take action. So you'll just act. The above examples are so part of our everyday writing that we don't even see it anymore. This example drives me nuts. And the other day I caught myself doing it. And I reprimanded myself fiercely. Please do respond before 3 October. I will do so. That do is completely unnecessary. It sounds wonderful if someone says it, like please do respond before the 3rd of October. It does sound lovely. But in writing, cut it out because it's just another word that a judge must read that's not going to contribute to any arguments and it's probably just going to annoy the presiding officer. So when you write in law, when I say to students, reread your work before you submit it, what I'm actually saying is go back and cut out what's not necessary. Meaningless adverbs. I absolutely hate this and I absolutely do this too. So this is something that when we reread our work to submit to that judge, cut it out. Very tragically. Let's look at the first example here. Chester versus Morris clearly held that bicyclists must adhere to the rules of the road. Why are you saying that they clearly held? Are there court cases that do not clearly hold? Just say S versus Smith holds that this. Clearly holds that that's completely unnecessary. There's no need for you to use those qualifications. Cut it out completely. Second example, the fact that he was drunk is extremely important. That sort of thing might work in any other profession on earth, but in law, you are annoying a judge because you are thicking it on. You are, pasting honey around something that you really shouldn't. If it's important, simply say that. Instead of something is very narrow, something is just narrow. It was understood in a narrow fashion. These are just some examples. This is something that happens frequently, and I make myself guilty of this all the time. I'm not going to go through all these examples, but this is what I always call in class the throat clearing expressions. I do this, especially in academic writing. But when I walk into a courtroom, this is the stuff that I'll try to cut out, even in my verbal arguments. I must say I try to cut it out in the oral arguments as well, but I definitely cut it out in my legal writing. I would like to point out that that stuff is unnecessary. Just say, begin where you should and end where you should. You don't have to include these throat-clearing expressions. I would argue that it should be noted that one thing that I see very often from students when they write emails, I am writing to you to ask. That is completely unnecessary. Of course, I don't mind it because you guys with me are not engaged in legal writing, but I'm not a judge. But when I am a judge one day and you guys are practicing before me, I will note in court when you use throat-clearing expressions. Judge Carol Lewis of the Supreme Court of Appeal, and her article, and I still have these articles if you guys are all interested, she begs. It's a plea for simplicity and clarity. For jettisoning, this is abandoning. Jargon and legal ease, and above all, a plea for brevity and clarity. So let's talk about tone. The tone is the amount of personality that shines through in legal writing. So I told you guys now about the frequency of newspaper articles that we read these days in which advocates or attorneys are lambasted for having been really rude to presiding officers. That's that's a discussion for another day. But in writing, be careful about tone, because tone is one of those things that can affect your case negatively and nobody even knows why it's happening. There's something about this guy's arguments that just not sits right with me. Make sure that your tone remains professional at all times. Even when, one of the very expensive lessons that I learned early on in my career is never ever send emails in anger. Draft that email and include all the colorful descriptions that you want, but save it, open it up again tomorrow before you send it. We've got another question. Do we have another question? No. So when you write, take note of the tone, keep it professional. If you are someone who like me, has an informal approach to things, who likes humor, that legal writing is not the place for it. So as much as your natural voice must come through, keep the tone professional at all times. Right, what is persuasiveness and what lies at the heart of persuasiveness? So I told you at the beginning of the speech that to be a lawyer and to be a good litigator, you must be able to do more with law than just apply the law to facts. You must be able to make arguments in any direction, for your client, against your client, pull the law apart, make the law do beautiful things for you. Persuasiveness is that incredible quality of doing that and then persuading someone that you should win, that your case is the one with the merits, that your case is the one that should be decided and is the truth. When the Americans talk about litigators versus your normal attorney, and in England they call it barristers, and I think that you also call it in Australia, it's also called barristers. Now, in the new Legal Practice Act doesn't really discern between advocates and attorneys, if I understand things correctly, but for me, the spirit of litigation still persists in some hearts and not in others. Not all of you guys will litigate one day. Some of you will try it and hate it. Some of you will try it and love it. It's not for everyone. The features of persuasiveness is important in all aspects of the law, not just litigation, but because that's my field of experience, that's where I usually go. But the quality or the skill of being persuasive, guys, it's a tremendous, powerful thing. Powerful attorneys are powerful attorneys because of the art of persuasiveness. The big names in South African litigation are people who have mastered the art of persuasion. And how to do that is an art much more than it is a science. So when I was sitting in court that one day, and the example I told you guys about the attorney who got up and he spoke for an hour and I daydreamed through half of it. When I was sitting there, I had this image in my mind, this scene from a movie, Raiders of the Lost Ark, or one of the Indiana Jones movies, where the hero, fights off all these people who want to kill them, and he does so in a very entertaining fashion. Anyways, I was lucky enough to work in a small town, in a township where very many brilliant prosecutors practice, and I had the incredible privilege of sitting in courtrooms and really seeing prosecutors who know their stuff go at it and just do an amazing job. And one of my more senior colleagues was really, really good at isolating what's important, stating it clearly, and sitting down. And he won case after case after case. He was truly a brilliant prosecutor. And every time that he would stand up, make an argument and sit down, and his opposition would get up and ramble on and on and on, I had this scene in my mind. There was one particular case that my colleague did. It was a rape case. And he was working against a very famous advocate in Bloemfontein, one with a very serious reputation. Let me put it that way. And my colleague stood up, did the final address to court, sat down. The opposition again rambled on and launched, personal attacks in every direction, and tried to intimidate all the parties in the court, and went on for quite a bit of time. And my colleague, prosecutors are allowed to reply, and stood up and on points of law offered the court a single sentence and sat down, and I couldn't help but smile. And again, this reminded me of this scene in this movie. I hope you guys can hear, but the hearing really is not that important. So this is what it feels like and what it looks like when you have a rambler versus a true litigator. So I don't know why I even included that in the slide, but that's always what my head goes to. So another judge in the United States gave these tips. How do you become a persuasive lawyer? And this was offered by the Honorable Michael Fitzpatrick. First thing, build a reputation. Nobody walks into a courtroom and they are a brilliant litigator from day one. Part of being persuasive is being believable. And believability comes with time. Building a reputation as a lawyer with integrity and a lawyer who is reliable. And I'm not talking about prosecutors. People tend to think, honorable, integrity, decency, prosecutor. That's not true in the remotest sense of the word. Some of the people with the most integrity that I had the privilege to work with were defense attorneys, defense advocates. Being persuasive means that the things that you say are true. They might be persuasive and they might be manipulative, but it's true. And that is why such a huge sense of importance is attached to you guys not committing plagiarism, you guys not submitting 2 assignments in 2 consecutive years for the same subject or for any subject. Why? Doing the right thing is expected of you because your entire career is built on the extent to which people can believe you. And that persuasiveness, it's fabulous if you can write well and if you can write persuasive. But if you have a reputation as someone who lies at every opportunity you get or take the shortcuts every opportunity you get, judges know this. They find out, and then everything you say, they have to go check themselves. They don't believe the arguments, and that is very, very harmful to any of your cases. Second, preparation. Please excuse the expression, but I always talk about the 6 Ps. Proper preparation prevents poor performance. And guys, that's true. That's incredibly true. As much as doctors must prepare for surgery, as much as newsreaders must prepare for each night's news reading, you have to prepare for each and every case. That leads to integrity, that leads to wonderful reputation, and that facilitates persuasiveness. Don't leave the work for the judge. So this attaches very nicely to the idea that applying the law to facts is not enough. You have to go further than that. You have to have the courage to go further than that. Don't make the judge do it, because the judge might find against you. Tell the judge, show the judge. In writing, they always say, don't say, show. Don't say that, ooh, the girl saw her dad being shot and she was filled with fear. Show me she was scared. She saw her dad being shot. She shivered. She glanced around. She started to cry. I am showing you that she was scared. I'm not telling you. In a similar vein, show the court what the decision must be. Don't say, find in my favor. Unfortunately, that doesn't work. By forming your arguments, show the court what the finding should be. The Georgetown University Law Center is one of the really reputable legal writing centers in the United States. They offer these tips for persuasive legal writing. So develop a theory of the case. What this means, and I think I miss this. I think a lot of defense attorneys miss this. When you prepare your client's defense, attach a theme to it. For example, I think the lawyers that work for Oscar Pistorius did a really good job with it. They attached to it the sense that we live in a dangerous country and this client was scared for his life. I mean, that idea permeated the entire case. We heard that everywhere. You couldn't go to bed without having heard it. So attach a theory to your case and try and work that theme into your arguments throughout so that it almost becomes something that people would advocate for. Consider who you are talking to. You don't want to annoy a judge. You don't want to say in every second sentence, oh, he was fighting for his life. Be subtle about it and guard against repetition. If you're going to repeat something, don't make it sound exactly the same thing. Tell a compelling story with the facts. Back when you guys did legal writing, I went on and on about how you should tell the story. Where do you begin telling a story? Start with an action point. In other words, if you are going to argue that your client had nothing to do with a crime, then start the story by how this poor man was arrested. Gosh golly, he was sitting watching the soccer and eating some, KFC, and the next minute, half the South African police force burst into his kitchen. So start with the action point, a point that is favorable to your client's case. Oscar Pistorius' lawyers didn't start with Riva, with the victim. That was the point where the prosecution would have started. They started with the story of the poor guy who was scared of crime. Include and emphasize useful facts. Downplay harmful facts. You are going to be the one that knows everything about your case. You need to have the court see the case through your client's perspective. That's the starting point of persuasiveness. Remember that first impressions count. If you read this sentence, and many of you would recognize this, he pulled out a gun and at point blank range shot the woman in the head. Who is the victim here? Who is the perpetrator here? If you state this different, if you start the story at a different point, pushing his son out of harm's way, he pulled out a gun and shot her. Now suddenly, having added just 2, 4, 6, 7 words, we have completely changed the sense of who's guilty here and who should be punished, isn't it? 7 simple words, and suddenly the entire story seems different. De-emphasize stuff that's harmful to your case. Emphasize what is very favorable to your case. We can't lie away harmful facts. We can't hide them, but you can soften them. Airtime, the amount of detail you use, the precision of emphasis. Look at this from the Oscar Pistorius trial. So read that sentence. Mr. Pistorius shot and killed Miss Riva Steenkamp where she was hiding away in his bathroom. He will allege that he murdered her in private defense. If you read that sentence, you should be able to tell me, a good lawyer should be able to tell me who wrote that. So who do you guys think wrote that? Let's actually ask you. I'm going to look at the comment section here. Let's see if any of you have the courage to say, who wrote this sentence? Or at least, if you had to take a guess, who would you think would write the sentence? Let's narrow it down. Someone is typing. If you had to walk into a courtroom and you heard someone say this, who would you think it would be? Very nice, very nice. Let's look at the sentence, shot and killed. Let's look at the word choices here, killed, shot. These are active voice. These are concrete terms that are used. The victim's name is typed out, Miss Riva Steenkamp. Where she was, the description of her hiding away. Remember, human beings listen in pictures. So her hiding away in a picture paints this really sad picture of someone who's scared and trying to sort of fight for their lives, or at least hide for their lives. Let's look at the last sentence. He will allege, the word allege. The connotation here is that we don't believe him, but he's going to say it, right? So he alleges. From a defense perspective, this prosecutor is going to allege stuff. But now the accused is alleging he murdered her in private defense. If you look at the second sentence, or at the second paragraph here, the deceased was shot where she was in Mr. Oscar Pistorius' bathroom. He shot her in defense of his own life. The deceased, not a name. We don't want to give her personality with grieving parents. She is just the victim. The deceased was shot. Look at the use of passive voice. Please don't use passive voice. It's a horrible thing, unless you want to soften something. The use of passive voice here takes the accused out of the equation. She was shot. He shot her, active voice. That's damaging. She was shot. Now suddenly he's not even in the room. The deceased was shot where she was in Mr. Oscar Pistorius' bathroom. It's his bathroom, you know. Mr. Oscar Pistorius. Now we want to give him grieving parents. So we want to give him a personality and personal life and personalize him to the courts. He shot her in defense of his own life. So this saying exactly the same thing, but from different perspectives, and you have two different stories altogether. Why would just to highlight the importance of word choice, why would the defense here not have said the deceased was accidentally shot? because that makes it sound like, you know, well, he can go home now. The defense was putative self-defense. So, in other words, he alleges that he meant to shoot, but he meant to shoot in defense of his own life. And that video that I showed the students on cross-examination was the moment where he started talking about he wasn't thinking, he just discharged, was the moment he lost the case, because now he changed his defense. And suddenly it seemed like automation. So you don't use words that can actually cost you the case, including the word accidentally here would have been completely harmful to the defense of putative self-defense. And you know, this may seem overwhelming, but you guys will see when you get to practice, you get into it, you learn so quickly. You all will be wonderful litigators when you get to practice, or at least after practicing for a while. Prioritize your strongest points in the argument section. You want to start with, like I said before, with your strongest argument, work your way to the weaker ones, because your position at the beginning is your strongest position. You want to, your judge is still paying a lot of attention there. So start with your strongest arguments there. Organize your arguments and your factual expositions in a logical fashion. Emphasize your strongest point and spend time on your own arguments. It's very good to anticipate what your opposition will do and to say, my opposition might argue that this, that, and the next thing, but don't spend most of your time there. Spend most of your time on your own case. And always use headings. Guys, headings are the secret weapon to clear writing. Make legal rules work for you. You don't have to state legislation and precedents exactly as it's written in the government gazette or in the court case. Frame legal rules so that it is beneficial to your case, because that is how you interpret it. And you want to show the court how it should be interpreted. Of course, you can't lie. You can't lie provisions into legislation. You can't lie about a court's finding. But your interpretation matters, and your interpretation in view of your client's case matters. Highlight your opponent's proof. You know what? Sometimes I think presiding officers forget that what reasonable doubt is. If your client is charged with a crime, you need to remind the court how high that burden is. Think about how wide or narrow you want a rule to be applied. Play around with sentences. Remember, at the beginning or at the end of sentences are positions of power. They tell us as lecturers, if you want students to remember stuff, say it at the beginning of your lecture or say it at the end. So normally when I begin a lecture, I talk about dates and all this useless stuff, and that's a mistake. Because at the beginning and the end of a speech, at the beginning and end of a sentence, and the beginning and end of a paragraph are the positions of power. So keep your important information there. Store your information at the beginning and the end of sentences. So this is an old example I've used in my study guides all these years. If you want to highlight information like I do here, you just keep it at the beginning or the end of a sentence. But if you want to tuck it away and make something else stand out, you can hide that harmful information in the beginning of a paragraph, like you see in the second paragraph here, the bold typed section. You also want to play around with sentence length. Personally, I think sentence length is the most neglected weapon in writer's arsenal. Don't make all your sentences equal length. That's death, because your reader's gonna be asleep within 20 minutes. Long sentences can hide harmful information. Shorter sentences, powerful. It packs a punch. It's going to be remembered. Research shows that information that's kept in short sentences are remembered longer. That is where you want to keep your most important information. Again, if you see here, the second to last sentence, in addition, she told the police that her assailant was in his early 40s. My client is 22. So my client is 22 cannot be forgotten, because it sort of really brings home the point that it's not her client that committed the crime, doesn't it? She told the police her assailant was in his early 40s. My client is 22. So the long sentence followed by the short sentence creates this contrast that also exists in the fact that the perpetrator is early 40s and the client is 22. So short sentence can be so powerful. On this point, if you look at the second to last sentence, in addition, she told the police that her assailant was in his early 40s. So in addition are two words, but it can also be called a, let me just go to the next slide. Oh no, I'll talk about that now. Let me just talk about active versus passive voice first. You always want to avoid passive voice. Passive voice is death to good writing. Use the active voice, unless you want to hide action. Passive voice draws the reader's attention away from the doer. Reeva Steenkamp was shot while Oscar Pistorius. The action is hard and the doer is clear. That I should have said Oscar Pistorius shot Reeva Steenkamp. It's active voice, it's the doer is pronounced, the action is pronounced. When you say Reeva Steenkamp was shot, you can even leave out the name. Then the doer is suddenly completely absent and the action is softened. So passive voice can be used, but only when you're trying to be persuasive and only when you're trying to soften harmful facts. Again, in this example, Mr. Pistorius shot and killed Ms. Reeva Steenkamp. So, of course, the prosecutor would use active voice, whereas the defense, the deceased was shot, would, of course, use the passive voice to highlight that information. When you have something that you want to hide or you have something that you want to emphasize, you want to also make sure that if you use a complicated sentence, that you include the important information in the main clause. A main clause can exist by itself. If you look at the last sentence in the first paragraph here, although the victim identified Mr. Ziller as the man who had approached her, that is the dependent clause because it can't exist on its own. The last part of the sentence, the witness did not pick Mr. Ziller out of the parade, is the main clause because it can exist on its own. There you want to keep your important information because that's going to be remembered. Main clause stuff is remembered. Dependent clause stuff is not remembered. Think about the language that you use. Use concrete descriptions. Don't be vague unless you want to be vague for the sake of hiding something. Stay away from those qualifiers. Think about how you are referring to parties. You don't want to give life to the opposition's client. Think about how you refer to your client, to the parties. And think about, the words have dictionary meaning, and then it has that connotation. Think about the words that you use and the connotation that it has and its dictionary meaning, and choose the right word. Rereading is your secret weapon. So look at all the spelling errors in that bad boy. That is how I wrote it when I typed out it for the first time. And then when I went over my slides, I saw my horrible spelling errors, and then I fixed it. Well, and then I thought, no, let me keep it that way and show you guys. I write and type every day of my life, and this is how I type. Still, I'm 1,000 years old, and I still have to reread my emails because there are always spelling errors in my emails. Rereading should be part of your strategy, and you shouldn't even think about it anymore. First drafts are never submitted anywhere. So rereading is your weapon because we can tell when a student reread or edited work. It's very easy to tell. Judges can tell immediately if work was reread, edited, or if it was not, if this is the first draft. They can tell. If you think they can't tell, if you think that they can't tell that you started this brief the night before, they can tell. Trust me, they can tell. So rereading, editing your work, that is the secret weapon. It's also points where you pick up, where you've not been particularly persuasive, or where you have been particularly persuasive. Look at me being brilliant, and then you hide that in your brain and you use it again in the next case. So something that some students always ask, and I'm always so impressed when students ask this because it is an important point. When we de-emphasize harmful facts and emphasize strong facts, is that not a form of, unethical behavior? A sense of lying to court. Lying to court is the biggest no-no for any lawyer. No, it's not. Remember, we use or we work in an accusatorial system where the opposition will always bring his or her A game. And if they bring their A game and you bring your B game, your clients will lose. And they will not come back to you in the future, and it will just be a question of time before your law firm becomes a statistic. We manipulate words to persuade someone of the truth of our case. That is part of taking part in the accusatorial system. Lawyers who are not ethical, who do not feel that their reputation or their moral compass is something important, would use words to manipulate, to believe a case that they know is false. They have to live with that. But we don't have to live with that. We practice the law the way we know how, with integrity and truth, and we try and get the judge to see that. Guys, that's my story. I took a really long chunk of your time to do it. I hope I contributed in some small way to your learning and to your success in your careers. I, again, just want to tip my hat to you that you guys are actually here on a Friday afternoon, a very gloomy Friday afternoon. And I'm here for any questions you may have. Thank you so much.
Thank you so much, Dr. Visser, for the informative session. I really enjoyed it. I don't know about the other students, but yes, Dr. Visser, I would like to thank you on behalf of Legal Behemoth for assisting us, for sacrificing just a few hours from your busy schedule just to assist us and the students. Thank you so much, Dr. Visser.
It's nothing but a pleasure. Thank you for inviting me. And again, you guys don't know it, you don't thoroughly understand it, but taking part in moot court and taking part in these training sessions, it's going to give you a leg up in practice. I promise you that. So good luck to all of you.
Okay, thank you, Dr. Visser, for mentioning that as well. I'm sure that everyone who's here will now understand the importance of participating in a moot court. Yes, Dr. Visser, Tashanta would like to extend her apologies because she's having network connectivity issues. So
oh, no problems. Now, listen, connectivity is supposed to make our lives better, but sometimes it doesn't. So please tell her that no problems.
Okay, thank you, ma'am. I just wanted to give the students an opportunity to ask questions just for a few minutes, if that's fine with you, Dr. Visser.
That's no problem at all.
Okay, thank you, ma'am. So guys, do you guys have any questions that you would like to ask Dr. Visser? If you have any questions, you can raise your hand or you can type them out in the chat box. So let's just give it a few minutes and see if there are any questions. Okay, so I haven't seen any question from my side. So I think I can assume that everybody is fine. No one has questions. But okay. Once again, Dr. Visser, thank you so much. Thank you for being with us this afternoon. And we really hope that you enjoy the rest of your day and the short break.
Thank you so much, guys. And I understand there are no questions. I think I overwhelmed you a bit. I had a lot to say. But if you have any questions that you want to just send my way afterwards, you guys know my email address. Please don't hesitate. I'm happy to help wherever I can. Have a very enjoyable, restful, short break.
Okay, thank you, ma'am. But before, I would just like to make two announcements to the students quickly. Okay, so guys, the first announcement is the reminder. Please, guys, don't forget to submit the summaries of the set of facts for the GSIP moot. Remember, these summaries are due on the 8th, I think. Yes, on the 8th, which is next week, Friday, if I'm not mistaken. So please don't forget that, because we use those summaries in order to select the people who are going to form part of the GSIP moot. And then it might happen that some of you wanted to participate so badly or in the GSIP moot, and then you end up not making it into the team. So I just want to let you guys know that it's not the end of the road. We still have the first moot. And as soon as we have received the facts for the first moot, we will send an announcement and an invitation to you guys, so you guys can have another opportunity to participate in a moot. And still, if you don't make it in the first moot, don't worry. Next year, there's still an opportunity to participate in the Nelson Mandela Moot Court and in the All African Moot. So yes, those are the two announcements that I wanted to make. So if there's nothing from anyone, then we can, before we conclude, Alfred, I see that Alfred has raised his hand. Alfred, you may speak.
Can you guys hear me?
Yes, I can hear you, Alfred.
Thank you, sir. Good greetings to Dr. Visser and everyone else. I just wanted to understand, Dr. Visser. You know, in your discussion, you mentioned something like when you write legal writing, you should try to be as concise